This video is part of a series on the Sue Neill Fraser miscarriage of justice case. If you are unfamiliar with this case and wish to hear an overview and information on other elements of it, you can find the link for my playlist in the description for this video. Whilst examining the yacht the Four Winds after the disappearance of Bob Chappell, forensic officers from Tas Police lifted a rather substantial sample of fluid from the upper deck on the starboard side of the yacht, close to the saloon skylight hatch. The sample was described as being clear with a slight tinge, covering an area of roughly 210mm by 260mm. In other words, it was a somewhat substantial sample, pretty much the size of a dinner plate. Due to the significant amount of liquid in this sample, it was believed to have been saliva, gastric juices, or a combination of both. With such a substantial sample, forensic scientists were able to extract a full DNA sample, which came back as belonging to a female. However, this was not originally found to be a match with any individual on the Tasmanian DNA database. In close proximity to the DNA sample, forensic staff also discovered a blue rag, which they described as being a face washer or towel. And in the laundry area of the yacht, they also found two other rags, which were stained with fresh vomit. These pieces of evidence were bagged, logged in as evidence, and sent to the forensic lab. However, not only were they not tested, but they were also apparently lost and then removed from the forensic worksheets and omitted from final reports. It seems likely that had these rags been tested, they would almost certainly have confirmed the presence of an unknown female on the yacht, and possibly also the identity of her accomplices. In early 2010, whilst Sue Neill Fraser was in Risdon Prison awaiting trial, the identity of the unknown female was discovered after DNA was routinely collected from a 16-year-old homeless girl, Megan Vass, who had been charged with theft. Her DNA was a match for the DNA found on board the Four Winds. This discovery should have led to a change in direction for detectives investigating the Bob Chappell case. Tas Police were in fact quite familiar with Megan Vass before Bob Chappell's disappearance. She was suspected of participating in break-and-enters with her then-boyfriend, Sam Devine, who was himself very well known to Tas Police as a petty criminal. It seems, however, that prior to her arrest in 2010, Megan Vass may have been protected by a particular police officer who has since retired. This female officer had been Vass's babysitter when Vass was younger. Whilst reviewing files in relation to Sue's case, Colin McLaren, retired detective turned investigator and author, discovered an instance where Megan Vass had been involved with a break-in in the suburb of Bellerive. However, at the request of her former babysitter, Megan's name was left out of the report. Tas Police knew that Megan's boyfriend Sam Devine and some of his associates had been performing break-ins and stealing from yachts. They also knew that Devine had a violent side. On the same day Bob went missing, other yacht owners came forward and told police about break-ins and thefts on their boats in the days and weeks prior to Bob's disappearance. Colin McLaren, during his investigation, questioned many yacht owners and discovered they had been quite often faced with the theft of goods from their boats. Beer fridges were emptied and equipment and gear were damaged or taken. This had become so common that they rarely called Tas Police, who they believed were somewhat apathetic and rarely did anything about it. On the night of Bob's disappearance, a homeless man, Stephen Gleeson, was sleeping in his car at Murrayville Esplanade. The dinghy from the Four Winds was later found only a few metres from Gleeson's car, so police spoke to him briefly that same morning. At that time, Gleeson mentioned he believed a 16-year-old girl had been on board the Four Winds on the night that Bob vanished. He also went into Tas Police in Hobart a few weeks later and told them the same story, yet no formal statement was taken at this time. Despite the DNA evidence and Gleeson's account of a 16-year-old girl being on the yacht, it seems that Tas Police had very little interest in Megan Vass. In January 2009, Vass was living at a home for homeless girls, Mara House. Having contacted staff at that home, detectives learned that not only had Megan Vass been absent from the home on the night of the disappearance, but had also lied to staff, saying that she was going to a sleepover in the nearby suburb of Mount Nelson and would be with her boyfriend. The staff reported that she had given them a fake address and also failed to ring them to provide a phone number for the place where she claimed to be staying. Strangely, Tas police did not see any of this as cause for concern, and no formal interview was ever done with Vass. Prior to Sue's trial, Sue's legal team had not been given access to the somewhat sizable police file on Vass, and having only become aware of this file during questioning of a detective Sinnott with regards to Megan Vass, after she'd already been questioned and released as a witness, subsequently had to make a request to the judge, Justice Blow, to be given access to the file. Prosecutor Tim Ellis argued that he did not want Ms. Vass's details to be revealed, whilst Sue's counsel, recognising the significance of Ms. Vass in terms of Sue's case, argued that this was important evidence. Justice Blow agreed to allow Sue's counsel to read the file on Megan Vass and ordered a recess to allow this to happen. However, he also allowed Prosecutor Tim Ellis to go first through the file with Detective Sinnott in order to decide what they believed would be appropriate for Sue's counsel to view. In other words, based on the court transcripts, it appears that Justice Blow allowed Sinnott and Ellis to remove documents from the file which they did not wish Sue's counsel to see, thus effectively avoiding full disclosure. Sue's counsel subsequently were given a few hours to read the file on Vass before the jury was recalled and the trial continued. This seems highly inadequate, as it would have most likely led to missed information and also would not have allowed Sue's defence team the opportunity to do their own research or to follow up on anything contained in the file. Having read the file, Sue's lawyer made 3 submissions to the court. 1. That comments and notes made by Detective Sinnott regarding Megan's absence from Mara House be admitted as evidence. 2. That the forensic scientist who analysed the DNA sample be recalled for further questioning. And 3. That Megan Vass herself be recalled to answer questions regarding her whereabouts on the night Bob Chappell was murdered, since, whilst she had denied being anywhere near the boat during her testimony, the information regarding her absence from Mara House on the evening of January 26 had not been known to Sue's counsel. Prosecutor Tim Ellis countered this by firstly suggesting the DNA was more likely a secondary transfer, inadvertently brought on the yacht during the police investigation. He also cited concerns for Megan Vass's welfare as being a reason not to recall her for, quote, a bit more nasty badgering about where she was on that night. The response by Justice Blow was to deny the requests made by Sue's counsel for the recall of the forensic scientist and Megan Vass for further questioning, and to order the jury to disregard the statement made by Detective Sinnott that Vass was absent from Mara House on the night that Bob went missing, since he had been given this information by an employee of Mara House in the form of an email, so the information was considered hearsay. If it had come from original documentation from Mara House, that would not be the case. This seems to be a somewhat odd decision, given that, for starters, the detective was doing his job when he questioned that employee. Wouldn't this mean that every interview done by detectives which was not done in an official capacity would be inadmissible? For example, the interviews done by Sue shortly after Bob's disappearance, and countless witness statements put forward by the prosecution. The judge's comment when denying the submissions by Sue's counsel was, "I wonder how relevant any of this is anyway." As so aptly put by Colin McLaren, despite Megan's puddle of DNA being found on the boat where a man had been murdered, the judge couldn't see the relevance of evidence that pointed to Megan Vass's whereabouts that night. Had the vomit-stained rags found on the boat been tested rather than misplaced by the Forensic Division of Tas Police, and had the issue of Megan Vass's DNA and whereabouts been adequately addressed during the trial, there would have been more than adequate cause for reasonable doubt and an acquittal. The past almost 15 years could have been very different for Sue and her family. I will be covering further developments in relation to Megan Vass in a future video, so please subscribe so you don't miss anything.